Time now for a debate. This time we hear from both sides on Proposition 136, which would allow courts to hear constitutional challenges to citizens' initiatives before they appear on the ballot. Currently, those challenges can only happen if and when an initiative is passed by the voters. Joining us now in support of the measure is Scott Musi. He's president of the Arizona Free Enterprise Club. And in opposition of Prop 136 is Penny Choron. She's president of the League of Women Voters of Arizona. Scott, Penny, good to have you both here. Thank you so much for joining us. Scott, we'll start with you. You're for this. You think this is a good idea. Why?
Yeah, no, I think this is a good reform to the initiative process to ensure, simply put, that unconstitutional measures aren't moving forward to the ballot. As you mentioned, the only process now in place that if a ballot measure is put forth to voters is to challenge the constitutionality after it passes, which ends up resulting in years of uncertainty because you have something to go into effect, the law goes into effect, and it could be months, if not years, of litigation to determine its unconstitutionality. And if it's determined it's unconstitutional, well, then you just went through years of uncertainty having that law in place. If Prop 136 passes, it ensures that litigation, if it's perceived that if the proposed initiative contains unconstitutional language, that can go before the Supreme Court. And the Supreme Court can make a determination if the language is constitutional or if it isn't.
Why do you think this is not such a great idea?
This is absolutely not a great idea because it is silencing the citizens even before they can bring a proposition to the voters. And so if in fact the Arizona legislature, which referred this particular proposition, cared this much about making sure there's no unconstitutional propositions on the ballot, it would be nice to see how they would have passed a similar ruling for their own laws that they passed, advised to be unconstitutional, and still passed it anyway, okay? So frankly, the way we see it as the League is this is ensuring that the citizens don't speak before and the voters don't get to hear from them.
And again, the purpose of this, since you can file suit after the election, and if it doesn't pass, then it's all water under the bridge. If you can do it afterwards, what's the point here?
Well, the point is that if something goes into effect and if it does become a law, it could be years before there's any sort of determination on its constitutionality, which can create just years of uncertainty related to that law. And we saw this happen a couple of years ago. There was a proposition passed in 2020. It barely passed, a statutory change dealing with a tax increase. And after 2 years of litigation, it was determined, in fact, by the state Supreme Court that it was unconstitutional. And the result of that, though, was years of uncertainty related to this new tax law, how to comply. It would have made a lot more sense if beforehand that litigation could have occurred to allow the Supreme Court to make a determination.
Would it have made a lot more sense and saved a lot of money just to go ahead and find out beforehand whether or not this thing is constitutional?
There are already checks and balances in place when citizens' initiatives are brought forward. There is the Joint Legislative Council review. Campaigns have their own legal counsel review. There is a budget review. The legislature has an opportunity to weigh in. So it isn't that there aren't many checks and balances already in place to determine if something is going to be constitutional or not. And one important thing that Scott brought up that I want to respond to is that when we tell a citizens group that something is unconstitutional, that the unconstitutionality is not a clear-cut decision. There isn't the amount of faith we ought to have with the judicial system that it is unbiased. There is nothing to say that the Supreme Court would rule in a fair and an unbiased manner. Second is the cost issue that Scott brought up. Why waste all that money up front? This only saves money for those who are opposing ballot initiatives because they can silence it before it even gets to the voters.
And I wanted to bring up cost and money as well. If I've got Prop Prop TED out there, and all of a sudden everyone's filing suit against Prop TED, it's going to be difficult for me to gather money and get funding for my particular campaign, because here comes a lawsuit, here comes a, you know what I'm saying? I mean, is it not a chilling factor, a chilling effect?
No, because these lawsuits wouldn't occur until after they've already filed their signatures, and they have to be concluded as required by the initiative 100 days before the vote occurs. And so the period in which you had the litigation would play out would be long before even ballots would be printed for that particular measure. So if somebody deemed it to be, or potentially could be, unconstitutional, that challenge would happen long before even the ballots would be printed.
But would there not be a concern regarding nuisance suits or anything to slow the process? It's one thing to get it on the ballot, but once you get it on the ballot, all of a sudden you got a campaign to get it passed, and it's going to be hard to find folks who want to fund up for something that could be unconstitutional.
Yeah, well, if it's something is unconstitutional, that is a serious question. The question of the debate over whether or not you're trying to file frivolous lawsuits, you can't do that. If you're trying to go in and file frivolous lawsuits, the courts have in the past demonstrated a willingness to reprimand attorneys and groups for filing frivolous lawsuits, like awarding attorney fees and others against groups that try to file frivolous suits.
You mentioned possible bias in the courts. That possible bias could occur before, during, after this process, could it not?
I think it's much harder to do, it's easier for the courts to infuse that bias before even the voters have heard about it. I think it's harder to do it because it's much more costly for those who oppose it. This is definitely, let's silence them. Because once it's spoken, once the voters have spoken, much harder to silence the will of the voters, okay? So that is something to recognize.
Want to respond to
Yeah,
that?
I'd like to respond to that. I think that accusing the court of saying that they're going to engage in a biased matter, whether or not it's before or after, I don't think is addressing the issue related to whether or not it's constitutional or not. But secondly is impugning the motives of the justices, that they're going to be influenced by matters other than the law. I think this is pretty straightforward. They can evaluate it based on whether or not it's constitutional or not. We should trust our justices and our court system to adjudicate that, and let that process play out before the election rather than have it drag out years afterwards.
And again, just for common sense purposes here, does it not make sense to keep voters from voting on something that's unconstitutional?
But there are checks and balances anyway before a ballot proposition makes it, a citizen's initiative makes it onto the ballot. And frankly, I would rather trust the voters and the will of the voters than the judiciary system.
And Scott, again, critics will say this is yet another attempt by Republicans and the right to keep the citizens' initiative process is constantly, it seems to be attacked, for lack of a better word here. And this is yet another attempt. How do you respond to that?
Well, I would say that this isn't a conservative or a liberal reform. I think this is a common sense reform related to the process dealing with the question of matters of law and whether or not something is constitutional or not. This doesn't impinge on any group's ability to collect signatures, to propose laws, even to promote it, to try to get it passed. It deals solely, specifically with the question of the constitutionality of it. And again, I think on the flip side, I think voters should have confidence to know that the laws or the proposed initiatives that they're considering to vote on are in fact constitutional or not. It just makes sense to make sure that we're preventing unconstitutional measures from appearing on the ballot.
All right, final word on this. Again, the idea being that I don't want to vote for something that's never going to make it here. Why not ensure it beforehand?
Why not silence them before they speak? Why not silence the citizens that are bringing? Why do citizens bring such initiatives forward? Because that the legislature has not done right by the will of the people. So that's why we have it enshrined in our constitutions that the citizens have the right to bring forward initiatives. So let's silence them even before they can speak.
Penny Sharon and Scott Musi, good conversation. Good to have you both here. Thank you so much for joining us.
Thank you so much, Ted.